not a sensation I normally feel, but it's a relief to come back into court.
Yes, Miss Darwin and I were saying that over lunch.
Yes. Yes.
I was addressing you before lunch, my lords, on my submission that the EAT took the wrong approach as an appellate court when determining what I characterise as an evaluative judgment, and that I said it wasn't open to the EAT to remake the decision. If I'm wrong about that, and it was open to the EAT to remake that decision, either on the basis that they hadn't identified an error of law, the wrong application of the test, or regardless of that, afresh. The question, I'd like to address you on the question of if it was open to the EAT to determine the matter afresh, then in principle it will also be open to you, my lords, to determine the matter of afresh. And in principle one could go up the chain of appellate level. So I'd like to briefly address you, if I'm wrong about my primary submission, that I ask this court to find, considering the matter itself, that the claimant's employment fell on the side of Lord Sumpter's line such that her employment was not an exercise of sovereign authority. There are two headline points I'd make before I identify, and I'm not going to go through every finding of fact from Employment Judge Brow, but I will take you to those which were seen to be particularly pertinent by the EAT, partly because those are before you, but also simply by way of example, I'd say, is that I say that the focus should be, and the ET's focus properly was, on the claimant's own particular functions, what she did, as opposed to what the mission as a whole did, and to her seniority. And in this context, I think it's helpful to start, if I may, with the Employment Tribunal judgment, and the finding of fact, which appears paragraph 134 of that judgment, page 201 of your Lordship's court. This is again the account of the claimant's evidence, but I've taken you to the ET's finding where she accepts the claimant's evidence as to her roles. The claimant denied that she had any ultimate decision-making capacity in any of the roles she undertook. And that is borne out by the example findings of fact I'm going to take you to. She is not a decision-maker. And that goes to the second of the 2 points of principle I identified, her seniority. Now, in terms of the example finding of facts that I'm going to take you to, I'd like to start, if I may, with those identified by Mr. Justice Bourne, and this is paragraph 97 of his judgment, page 161 of the court.
Just before we leave 134, the claimant denied she had any ultimate decision-making capacity. Was it alleged that she did have any ultimate decision-making capacity, and did the judge make findings?
Well, my lord, I say that it was alleged, I think in general terms, that she was a decision maker, but I say that the claimant's account of her role, which is set out in the Employment Tribunal's findings of fact, between paragraph 116 and paragraph 134 of the judgment, is, if one looks at paragraph 150 of the judgment, page 204 of the court.
Yes.
I accepted the claimant's evidence regarding her job responsibilities. So I say that one reads this judgment as a finding of fact by Employment Judge Brown that where the claimant gave evidence as regards her responsibilities, that evidence was accepted by the first instance tribunal.
But the way it's worded suggests, as my lord postulates, that the fact she denied means that it was probably put to her.
Yes, my recollection, and I'm speaking no more of my recollection from a hearing in 2021, I don't have the witness statements with me, my lord, is that it was suggested that she made decisions. I don't remember that the evidence being particularly specific, but I'm open to correction
Either
at that
way,
point.
it's a finding.
Yeah. Bearing in mind the particular factors identified by Mr. Justice Bourne in the EAT as he felt indicative of her employment being an exercise of sovereign function, we have 15 compliant and non-compliant guarantee requests. And this is dealt with at paragraph 150 of the ET judgment, page 204 of the core. Claimant's role here is checking the documentation is complete. If the documentation was complete, the claimant would forward the request and documentation to her head of department. And that needs to be read, I say, with the findings of fact at paragraph 120 that start on page 199 of the core, which gives the claimant's evidence on that, which I say was ultimately the judgment shows was accepted. And you'll see at the end of paragraph 120, the claimant said she did not sign the relevant guarantee letters herself. We then have the findings at paragraph 1353 of the judgment, page 204 of the core. Students would make a request for funding and support. The claimant would write a report for Dr. Bengali, that's her line manager, which summarised the project. The cultural attaché, not the claimant, would then decide whether to support the project and offer funding. And then if the project was approved, the claimant would ask various UK universities about it, assisted with practical arrangements. Again, this is a role, I say, that shows that this is someone carrying out administrative functions, event organising functions, the sort of functions that might be carried out by an individual employed by a private entity. The nature of her functions are not necessarily sovereign functions, and she is not sufficiently close. Her seniority is low. And the last finding of fact identified by Mr. Justice Bourne is discussing art exhibitions. The finding of fact in relation to that is paragraph 125, page 200 of the core. Again, it's within the account of the claimant's evidence as to her job role, which the tribunal accepted. She attended an exhibition of the history and future of Saudi Arabia, in which Saudi students shared their art. She was involved with an art exhibition and assisted students in explaining their art. She also helped to sort out technical problems. It's not a senior role, but it is a role which might well be carried out for a private interest. It's administrative, it's events organisation. And in that context, I say, looking at those findings of fact, I say that those are indicative examples of the findings that the tribunal made. They properly represent the findings read as a whole, that these are administrative events organising functions at a relatively low level. And if it is open to an appellate court to remake the decision, I ask this court to agree with the Employment Tribunal. Just dealing with what the embassy says about this in its skeleton, it refers to the Holland case, the House of Lords case that I've referred to, and suggests...
Sorry, which page?
99.
The Holland case...
No, that you took us to the respondent's skeleton, but you didn't give a page.
Forgive me, paragraph 130 of the skeleton,
Thank you.
page 38. The embassy's involvement in the educational activities of its citizens in the UK is part of its sovereign activity. That may be. And then in Holland, the House of Lords found that the educational activities was part of sovereign activity. Now, it may be that educational activities are part of the mission's sovereign function, but that, of course, is not the Benkar-Boucher test. The Benkar-Boucher test is whether or not an individual's functions are sufficiently close. And it is...
It's all a matter of fact. We keep going to these cases, but surely it's all a matter of fact.
Yes, in the case I was...
And in the case of Holland, looking just all I know is from this paragraph in the skeleton, it wasn't just educational activities for military personnel and their families in the UK. So
On a US military base, my lord.
yeah,
And it's the point that's been made by my Lord Justice Coulson. But in Holland itself, if one looks at the case, which is in your volume 1 behind tab 14, page 203 by the letter E in the margin. The solution in any particular case where the question of state immunity arises at common law has to be one of the analysis of the particular facts against the whole context. There is little, if anything, to be gained by trying to fit the case into particular precedent or to devise categories or situations which may or may not fall on one side of the line or the other. It is the nature and character of the activity on which the claim is based rather than the motive and purpose of it. And with that in mind, and therefore with some caution, I would just briefly like to go to the Constantine case and the assessment of those facts. That is volume 4 of your authorities, my lords. Behind tab 46. And the Supreme Court's decision, paragraph 73, page 1203 of the authorities bundle. This is the Supreme Court's determination of the substantive point, and I pause to note that the approach taken by the Supreme Court in this appeal is very much the approach of an appeal court on review. You'll see for example, at paragraph 73.4, contrary to the submission of Mr. Seffi, the judge did not fail to give proper weight, and you'll see the end of paragraph 73(4) by H in the margin on page 1203, was clearly entitled to come to her conclusions. So the point wasn't argued before the Supreme Court in Constantine, but it appears to have been approached on the basis, with no dispute from any party, that the approach to be taken was one of review. But in terms of the substance of this decision, there is an identification of Miss Constantine's functions. It is necessarily very brief, but you will see at paragraph 73(3)(a), paragraph little 3 by letter E in the margin on page 1203, the focus on the administrative nature of the job, a data entry job at paragraph 3A, and 3B, her functions in the Cultural Affairs Department. There will be, and I make this submission cautiously because I'm mindful of what it says in Holland about being wary of seeking to identify categories, but I say that there are significant similarities between the functions identified for Miss Constantine. Her employment is not an exercise of sovereign function following the Supreme Court's decision, dealing with events organisation for the Cultural Affairs Department of the Royal Embassy of Saudi Arabia. Those were my submissions on the appeal. You asked My lord asked me before lunch a question about paragraph 88 of the EAT's judgment.
Yes.
And I've reflected on that, and I would like to
Yes.
answer that if I may. And I'm grateful for the time. My lord asked me about paragraph 88 of the EAT's judgment, page 160 of the court.
It was, the point was only the only one right answer.
Yes. So I've reflected. I maintain my position that this is an evaluative judgment. It's a classic evaluative judgment. Facts. In those circumstances, it seems to me that I don't think there is only one right answer. On reflection, I think that is the nature of the evaluative judgment. If I am wrong about that, I don't see that it changes the position that the appellate court should still approach a first instance decision by way of review, which means that the appellate court must approach it by seeking to identify material error rather than simply remaking the decision. And the principal reason for that, I suppose, may be that it is the first instance judge who saw the evidence, the familiar paragraphs that we looked at within the sprint room decision, is more likely to have got it right. They saw the evidence, and any written judgment is necessarily imperfect.
Yeah. Well, the other side of the coin is that on the authorities, we can only interfere if we're satisfied that the judge got it wrong.
Yes. But what does wrong mean in this context?
Wrong
doesn't mean one does not determine what wrong means by starting afresh.
No.
One considers if it was wrong by way of a review and identifying a material error. Those were my submissions on grounds 2 and on grounds 2 and 3. We have touched on it, but just for clarity, the embassy's skeleton helpfully at paragraph 134 and 135 seeks remedy. Just for clarity, the embassy says at paragraph 135, the EAT remitted the issue of waiver submission back to London Central ET, but to a different judge. That is true. That is the order against which I appeal and ask you to set aside. However, this need not occur if this has been rendered academic by this court dismissing the claimant's claims.
Yeah.
I don't accept that that is a path open to you. There is no cross appeal by the embassy against that paragraph of the order. It is not clear to me the basis on which the embassy says that you could do that.
I'm not, maybe me, but I don't read the skeleton as saying that there would be a cross appeal which we would allow. It simply says that there'd be no point in going back to determine the waiver if your client had lost on every other ground and the claim was effectively at an end.
Yes, well, if that is the embassy's case, then I dispute that, and I should make that clear. And that is because if the embassy submitted to the jurisdiction under the waiver point, then it does not matter if her employment is an exercise of sovereign authority and it is not a personal injury claim, because there is no dispute between us that the embassy can submit to the jurisdiction, and had it done so, that is enough to give the Employment Tribunal jurisdiction.
Yes.
And I do not think there is any dispute between us that the email from Howard Kennedy on April 2019 and the steps would have constituted submission to the jurisdiction, and the only basis on which the embassy said they didn't is that, as a matter of fact, the head of mission or the person exercising his functions had not authorised it. It's that point of fact. So I do not agree that it could possibly be rendered academic by anything my lords will determine, because if they submitted to the jurisdiction and Mr. Justice Bourne has remitted that point, then the Employment Tribunal has jurisdiction to hear this case, regardless of whether or not Ms. Alhayali's employment was an exercise of sovereign authority, and regardless of whether or not it is a personal injury claim. That is the reason why, in my submission, it was appropriate for the Employment Tribunal to deal with these issues in the order that it did. It dealt with every issue, but in theory it could have stopped after the waiver point, because if the embassy had submitted either explicitly or by taking steps, That was the end of the story, and the Employment Tribunal had jurisdiction on that basis. Following that, if Ms. Alhayali did not succeed on this point, and they had not submitted, then the Employment Tribunal might nevertheless have jurisdiction if her employment was not an exercise of sovereign authority, the Ben Carbuchet points. If Ms. Alhayali didn't get home on that, she said, even if you haven't submitted, even if her employment is an exercise of sovereign authority such that you would otherwise be immune, Section 5 is a freestanding exception, which means the tribunal has jurisdiction to hear this case insofar as this is a claim for personal injury, which may well mean some of it and not all of it. And that is why I suggest it was appropriate for the Employment Tribunal to deal with it in the order that it did.
Yep.
Unless I can assist you any further?
And on that last point, you say that if you lose on the substantive point, Section 4, Section 5, you want remittal as a fallback. Is that right? If you lose on the substantive points, you say you could still win outright if there was a clear waiver. So it's a fallback for you.
Yes, my lord. Did I already have that fallback? That is Mr. Justice Bourne's order.
Yes.
If I am not successful on either of my grounds of appeal, we go back, if we choose to do so, to the Employment Tribunal, and that is redetermined at a fresh hearing in front of a different judge, because that is Mr. Justice Bourne's order.
Whereas if you win on the substantive points, or either of them, you don't need the waiver point then does become academic.
If I win on my ground 1, then you will not be ordering remittal, because you will say there is no error in the ET's decision, and paragraph 1 of Mr. Justice Bourne's order should be set aside, so remittal will not happen. If I win on the Ben Carbuchet points on grounds 2 and 3, then the waiver point becomes academic, because whether or not the embassy waived immunity, the Employment Tribunal had jurisdiction anyway, because the claimant's employment was not an exercise of sovereign function.
Yeah.
I ask you, of course, to determine it on all bases, but it's a matter for your lordships.
Good. Thank you very much, Ms. Stanley. Thank you. Yes, Ms. Darwin.
Yes. Good afternoon. I appear for the embassy alongside Mr. Legg.
Yes.
In accordance with the practice direction, Mr. Legg will address you shortly on ground 1 of Dr. Alhayali's appeal. But before if he does, if I might quickly give you an overview of the embassy's case in relation to the 2 appeals. As you know, Mr. Justice Bourne, we say correctly, held that the embassy had entered into a contract with Dr. Alhayali in the exercise of sovereign authority, and Mr. Justice Bourne also, we say correctly, heard that the Employment Tribunal had erred in law in completely failing to consider and to take into account the official stamped statement when deciding the question of waiver. However, Mr. Justice Bourne nevertheless permitted the claimant's claim to proceed to trial under Section 5 of the 1978 Act. That is the personal injury exception. The reason being was because Dr. Alhayali had brought a claim for personal injury damages as part of her Employment Tribunal claim. And the Employment Appeal Tribunal was constrained by the judgment of Ogbonna, which we'll look at tomorrow, to find that the correct interpretation of Section 5 was that it allowed Dr. Alhayali to bring her personal injury claim in those circumstances. The embassy invites this court to find that Dr. Alhayali cannot bring her claim, her employment claim, against the embassy pursuant to the personal injury exception at Section 5. This is not a mere matter of comity. As a matter of international law, the Kingdom of Saudi Arabia has a right to immunity under international law. This is, as we'll come on to explain tomorrow morning, a right or wrong question. And not only does the Kingdom of Saudi Arabia has a right under international law to immunity, but the United Kingdom is under a corresponding obligation to respect and give effect to that immunity. and the embassy submits that the order made by Mr. Justice Bourne erodes that immunity and is incompatible with the United Kingdom's obligation to respect and give effect to its rights and not to intervene in the sovereign affairs of another nation. And we say that that interpretation of Section 5 of the 1978 Act, so allowing embassy employment claims to be brought within the personal injury exception, would essentially license judicial intrusion into the core sovereign functions of every diplomatic mission on British soil, which would be an abrogation of the duty long recognised both in domestic and international law not to intervene in undisputable sovereign acts, such as the employment of members of the diplomatic mission who are exercising sovereign functions, as Dr. Alhayali was. Accordingly, we say that this court is constrained by international law, hence the right-wrong question to find that Section 5 can't be so interpreted, and that otherwise there would be a breach of international law. As I said, to maintain the same order as Ms. Stanley, we will start with ground 1, the official stamp statement, and my learned junior will address you on that issue. I will then address you on Dr. Alhayali's grounds 2 and grounds 3, and tomorrow, after Ms. Stanley's reply, I'll then address you on the personal injury exception.
Good.
Unless you have any further questions on the overview, I'll hand over.
No, thank you very much. Yes, Mr. Legg.
Good afternoon, my lords. I'm addressing Dr. Alhayali's first ground, that is whether the EAT erred in finding that the ET failed to give any weight to the embassy's official stamped document. And the embassy's embassy's case on this ground proceeds in 4 stages. Firstly, that waiver of state immunity is resolved as an issue of fact. In particular, whether, in fact, the ambassador or the person performing the ambassador's functions actually authorised the waiver of immunity, ostensible or apparent authority not being sufficient. Secondly, the appellate court can and should interfere with such findings of fact where there is an identifiable error, including where material evidence was not considered or was misunderstood. These circumstances are not limited only to perversity challenges, where the assessment of evidence is rationally insupportable, or where a rule of evidence requires a document to be given a particular status. Thirdly, the judge was right to find that at the crucial stage of the Employment Tribunal's analysis and reasoning, the embassy's official stamped document had been disregarded. It was not given any weight at all when it should have been considered. My learned friend is with
Should have been
considered.
Should have been considered.
Yes, my lord. And my learned friend is, with respect, wrong to suggest otherwise. Fourthly and finally, my learned friend's other arguments that, for example, that the decision could not be justified without a finding of perversity, or that unless there was some other rule of evidence that specified the weight, the thumb on the scales, as she put it, unless there's a rule putting thumbs on the scales, those arguments are either wrong or misdirected because they don't address what the judge actually decided, namely that the document had been disregarded. So taking each of these 4 stages one by one, turning then first to the first stage, this is something I should be able to address relatively briefly because to a degree it's common ground between us, I think. That is that this is an issue of fact and one that does not engage ostensible or apparent authority. Now, my learned friend's skeleton at paragraph 15.1, just for your notes, I don't necessarily propose to take you there, sets out that particular point that this is a question of fact. And so between us there isn't a lot, but I'm going to say a few things about this point.
Where did the burden of proof fall on this question of fact? On the embassy or on the claimant?
I think That's a good question, my lord.
Thank you.
And it's caught me slightly. I'm not entirely. I think the answer is that when one is relying upon an exception to state immunity, as this is, submission is an exception to state immunity in section 2, which I'll come on to in a moment. The burden is on the party who wants to take advantage of the exception to state immunity to establish that fact. Now, obviously, there's a sense in which if all of the evidence can only be available on the other side, then the burden can often shift, as is often the case. And in that sense, the tribunal will have to take account of all of the evidence.
You say once you've got a state,
Yeah.
the default position is immunity, unless it's waived, and so it's for the claimant to show that it was waived.
Yes, my lord. Yeah.
And you say, whether that's accepted or not, the ambassador has to authorise it. So the
Yes.
claimant has to prove the ambassador authorised the waiver.
Yes.
So in the case of a solicitor's letter or email, the claimant must prove that the solicitor was authorised by the ambassador personally.
My lord, yes, that's right. But of course, like as I mentioned earlier, if the evidence is all on the other party's side and it's something that the claimant is not able to know, for example, the interactions between a solicitor and its instructing party, then routinely the burden at that stage, if there's a prima facie case to answer, then the burden would shift to the embassy, as in this case occurred, because we have the email. Prima facie, it looks like that email was sent with instructions, and at that stage, there's a question to be answered.
So the danger of getting down a rabbit hole with this, but the burden of proof rests on the claimant. Once the waiver has been given by the solicitor, there's a forensic
There's a question. There's a
burden
question
put
to
on
be
you
answered.
to show that that wasn't a proper job.
Yes, and the issue of burden of proof is not something that's between the parties, as I
No,
understand.
no. Thank you.
No, and my learner leaders reminded me it didn't come up before the tribunal or before the EAT.
That's what we're here for.
Very good.
Yes, here to help.
And the question of ostensible authority and the fact that that is not available in the circumstances of state immunity is dealt with, for your notes, in the EAT judgment briefly at paragraphs 42 to 44, and probably quite briefly because there wasn't a lot between the parties about it, and by the Employment Tribunal in a little bit greater detail between paragraphs 84 and 98. The relevance...
You say there's common ground that ostensibly putting state immunity to one side in any other sort of litigation I've ever been involved with in the last 40 or 50 years, when a solicitor sends a letter saying we act on behalf of X and we admit liability, or we submit to the jurisdiction, or we do this or we do that, the solicitor has ostensible authority. But you say that in state immunity cases it's completely different.
That's
You
right,
assume nothing.
Absolutely.
The ambassador can wait until perhaps the eve of the trial, or maybe on appeal if the trial's gone badly, and said, hey, you know, those solicitors were never authorised.
Well, my lord says that the ambassador might wait. I think in practice what might happen is a state is a large entity and can be multiple types of litigation, and the ambassador may not be aware of all cases. And what it actually is required is that the ambassador must turn his or her attention to the case, and if a waiver is going to be chosen, authorise it. And if that doesn't occur, then the state has not waived state immunity.
Well, that's your case.
Well, that's the law, my lord.
Well, that's your case.
And that's my case and what the law is.
That's your...
So your answer to my lord is yes, he can wait, as happened here over 2 years.
If he knew and waited, then yes, my lord, but I don't accept.
Well, whether he knew or not, there can be a delay of over 2 years.
Correct, my lord.
Which
yes.
in most forms of civil litigation, the trial would be over in that sort of time.
Yes, my lord. Yeah. In principle, it is possible that there could be a delay before there has been any correction of a waiver that took place without authority. that can take place. But that's part of the nature of state immunity and the significance and importance that the law places upon upholding state immunity. My lords, if I can ask you to turn up the State Immunity Act at tab 1 of the authorities button. I'm working from here from the up-to-date version of the State Immunity Act. So section 1 is the general immunity from jurisdiction, and as you see in subsection 2, a court shall give effect to the immunity conferred by the section even though the state does not appear in the proceedings in question. And that has been interpreted as giving rise to a positive duty upon courts. My learned friend mentioned earlier that even if a state does not appear at the hearing, then it's incumbent upon the court to consider the issue of state immunity. And then if we turn to next, section 2, and just the heading above that, exceptions from immunity. Section 2 is the first exception from immunity. And subsection 1, a state is not immune as respects, it respects proceedings in respect of which it has submitted to the jurisdiction of the courts of the United Kingdom. It, the state, has submitted. Paragraph 3 is about deeming, subparagraph 3 here, if it, the state, has either instituted proceedings, or subparagraph B, if it, the state, has intervened or taken any step in the proceedings. So the mere fact that a step has been taken purportedly on behalf of the state is insufficient if, in fact, the state has not taken that step.
You don't get that from the
don't.
words,
Sorry.
do you?
No, my lord, that's a submission I'm making.
Yeah, I was going to say.
Yeah.
Because deeming is usually a mechanism by which something is deemed to have occurred, and you don't worry about the facts. So step in the action, you can prove a step in the action, you're deemed to have submitted to the proceedings.
That's right. And so this is why we have subsection 7. How do you figure out whether or not the state has in fact submitted? And there, this is another... This answers that question and explains why it's different in a situation of state immunity. If you didn't have this particular provision, then the court wouldn't be in a position to know whether or not, in fact, the state had submitted. Because there may well be a number of different channels that would have to be pursued before authority can be given on behalf of the state to submit to the jurisdiction of a foreign jurisdiction. But in the case of an ambassador, the law is clear here at subsection 7 that the ambassador or the person for the time being performing his functions shall be deemed to have authority to submit on behalf of the state in respect of any proceedings. So if it can be established that the ambassador gave authority, then in those circumstances, a step has been taken with the authority of the ambassador and on behalf of the state, and otherwise not.
Again, the words are I understand that submission, but the words are to have authority to submit, which takes you back to your subsection 2. I understand that submission, that they may submit. It doesn't say anything about taking a step in the action, let alone being deemed to have taken a step in the action.
I'm referring to subsection 3 there, my lord.
Say again?
I'm referring to subsection 3.
I am,
3B.
yeah. It's just, I, being a stranger to these provisions, I have to say, I understand the submission about subsection 7 and interplay with subsection 2,
Yes.
but I don't with 3.
Subsection 3, if a state is deemed to have submitted
If a state is deemed
Yeah.
to have a state is deemed to have submitted if it has intervened or taken a step.
Yes. And
Nothing to do with anybody's authority.
Well, it's if the state has intervened or taken a step, and then there's the question arises: has the state intervened or taken a step? And if you have somebody taking a step purportedly on behalf of the state, but without the authority of the ambassador, then that is not a valid step taken in any proceedings.
But that would render the deeming provision in 3 completely otiose. you wouldn't need to worry about taking steps in the action. It's all about authority. What would be the point of 3? What would be the point if it all comes, if you're right, and it all comes back to the ambassador's actual authority? Why bother to have complicated provisions about deeming a submission if you've intervened?
I think the answer, my lord, is that if a claimant who is bringing proceedings against the state is then faced with a response from the state, they may not be in a position to know whether or not the ambassador has given authority. But if the state then takes steps in the proceedings, and there is no question of waiver is raised by the state, then one can assume that the state has taken steps in the proceedings with authority.
Well, that's what happened here for 2 years.
That's
you can
right.
assume that.
You can proceed.
But if you
on
can
that
then
basis.
claw it all back. Anyway, there it is. I understand the submission.
My lord, the Court of Appeal did grapple with this issue in as is.
Well,
They did.
I saw that this morning.
Yes.
Is that the only case in which this point has come up?
I don't think it's the only case that's considered this issue, but it's the leading authority on how to interpret.
I was
question
surprised
of
when you took us to Aziz. I was surprised. I had been reading subsection 7 of section 2, simply making it clear that the ambassador or the head of the mission in the UK, as a matter of statute, has authority to act on behalf of the state. You don't have to go back to the home country and get something from the Minister of Foreign Affairs or whatever it might be.
Yes.
And that it was a freestanding clarifying provision separate from subsection 3. And then Aziz says to the contrary.
Yes, my lord. If we may turn to Aziz. Actually, before we leave the State Immunity Act, lastly, just a point for your note, section 22, subsection 1.
Section
22, subsection 1. This is just a minor point that the State Immunity Act applies not only to courts but also to tribunals as well.
Right.
Yeah.
So turning to Aziz, it's in Authorities 1, tab 17, page 228. And Mr. Aziz was an accounts assistant. You see that from paragraph 2 of the judgment, working at the Yemeni embassy. And before the Employment Tribunal, there was no evidence that there had not been a waiver of immunity. The question of immunity was challenged on a slightly different basis, namely that the embassy wasn't aware of facts that would entitle it to claim immunity. But before the Employment Appeal Tribunal, evidence had been adduced to the effect that there had not been any authority given for the submission to the jurisdiction. And on appeal to this court, the principles applicable to determining whether there had been submission in fact were considered in the judgment given by Lord Justice Pill. If I could ask you to look at paragraph 20, which is on page 234 in the bottom right-hand corner. You can see there the second half of the paragraph that the point hadn't been taken before the matter got to the Employment Appeal Tribunal. And at 29, paragraph 29, right at the end of paragraph 29 on page 237 of the bundle, this was a new major dispute of fact which had arisen after the hearing before the Employment Tribunal, that it was necessary to resolve an appeal. And then at paragraphs 41 to 61, the court considered a variety of authorities, and beginning with the case of Bacchus, which my learned friend referred to this morning, she took you to paragraph 45. If I could ask you to look, please, at the bottom of page 240, at the bottom of paragraph 43. There's a quotation from Lord Justice Parker which makes a similar point to the one my Lord Justice Bean made, that it would be surprising that one could for proceedings to go on for a while, and then for there not to have been authority and waiver. But importantly, that was not sufficient to undermine the argument that authority had not been given. The question arises as a matter of fact, did or did not the ambassador give that authority? And then just turning over the page to paragraph 45, which is the quote that my learned friend went to, it's important to note the consequences of waiver. The quotation starts off, in those circumstances, it seems to me that it requires some solemn act of the foreign sovereign to bring to life something which is otherwise completely dead. A claim that has been proceeding, absent authority, is a nullity, and there is not something that is other than dead, using the language from Lord Justice Parker quite colourfully. And in order for it to be resuscitated, there has to have been established that the authority in practice authorised it. Paragraph 47.
What do you say about the last few lines of the quotation from Lord Justice Parker? If the foreign's, I don't think any person, even though he be a foreign sovereign, would be likely to be believed if, in such an extreme case, he were to come forward and assert he had no knowledge whatever of the proceedings.
Yes, my lord, if it were known that there was a case afoot by the person with authority to waive state immunity, it would be surprising if that were permitted to continue for some time without any action being taken. There's no suggestion here that the ambassador knew about it and did nothing about it until the matter was brought to his attention.
Well, we'll come to the facts.
We haven't got a full decision in Lord Justice Parker's case, have we?
No, my lord, we don't, but if it would be helpful for us to dig it out.
I think it would be, wouldn't it, to see the facts.
My learned friend does have copies with her key.
Right, well, we won't be distracted now, but it'd be useful to have.
I'm grateful, my lord. At paragraph 47, just to note the point that in both Bacchus there was a consideration of the evidence, and likewise in the Craina and the TAS agency case, which I'll come on to talk about a little bit later, there is a reference there to evidence. The certificate of the ambassador, which not being conclusive, is evidence of very high evidential value, and in a matter of this kind, I'll come back to that later, is probably the best kind of evidence that can be procured. Then,
So in Bacchus there was evidence from the ambassador, and in Cregina there was a certificate of the ambassador.
yes, my lord.
Yep.
And then paragraph 51 draws together the principles from the discussion of the authorities. And the one I would like to emphasise is at B. In a case where the other party claims that there has been a waiver of immunity, the court should scrutinise, and I emphasise that word, the available evidence. Paragraph 52 addresses again the point of surprise on the part of the Employment Tribunal. It would be bizarre if solicitors would be acting without instructions from their client. And similarly, in this case, the Employment Tribunal at paragraph 109 expressed disbelief that solicitors would act without the proper authority. And in my submission, it's well understood that it would be ordinarily an oddity, but as I've said earlier, this is state immunity and the situation is slightly different, and the rules are a little different, and one has to look at what in fact the ambassador has and has not authorised. And the complexity is that, unlike for a usual day-to-day case, the run-of-the-mill matters in litigation, a solicitor will act and assume that there's authority. It may well be the sort of thing that could be missed, that actual authority on the part of the ambassador has to be taken in order for there to be waiver of immunity and submission to the jurisdiction of the United Kingdom. 53 and 58. I think my learned friend took you to paragraph 58 that underlined the fact that ostensible authority doesn't apply, but that also is helpful if one looks at paragraph 53, there's an analysis of section 2.7 that Lord Justice Pill refers to in Dickinson on state immunity. And if I could ask you just to read that quote, because he adopts it and accepts that.
Sorry, which paragraph?
Paragraph 53, the quotation from Dickinson.
That's what I understood. It was clarifying that if it's an individual whose role is specified in section 2.7, then they have authority. But in other cases, the authority's representatives must establish by evidence if it's challenged. So that rather fits with the understanding I had before we started today.
And then if one looks at paragraph 56, this is the nub of the matter. The ratio of Lord Hill is encapsulated neatly in paragraph 56. I could ask you to read that, please. Says only if a solicitor is authorised by the state, that is, the ambassador, directly or indirectly, can there have been valid submission. And this is the paragraph that's extracted at the judgment of the EAT at paragraph 43. Now, it's right, of course, that this is a question of fact. One has to consider the evidence. It is permissible in suitable circumstances for the tribunal to draw an inference, but it is also necessary that a question of fact takes into account and scrutinises all of the available evidence. My Lord Justice Bean asked my learned friend that if the Employment Tribunal had accepted that the statement was true and that the ambassador had not authorised the submission to the jurisdiction, would that be the end of the matter in terms of waiver? And the answer to that is a clear yes. The relevant factual background in the case is not controversial. I don't propose to spend too much time on it. It's helpfully summarised by the EAT at paragraphs 2 to 8 of the judgment. In a nutshell, there was an email sent on the 9th of April by the embassy's then solicitors, April 9th of April 2019, then solicitors purporting to waive state immunity. And on the 4th of August 2021...
Yes, well, Ms. Stanley took us through that, and I imagine you accepted it.
Yeah. Thank you, I'm grateful. So that is the first stage of the analysis. It's a question of fact. Ostensible authority is not sufficient. The next question then is, if an employment tribunal has made a finding of fact on that question, is it permissible for the appellate court to interfere with that finding? And the answer is yes, where there is an identifiable error, and it's not limited only to perversity. If I could ask you to take up Authorities Volume 2, please, of the Supreme Court decision in the case of Henderson and Foxworth Investments. That's at tab 25. This is a case relating to the liquidation of the Scottish Golfing Hotel. Facts don't need to concern us. The Supreme Court considered the principles applicable to appellate review of findings of fact. And the principles are discussed at paragraphs 58 to 68 of the judgment of Lord Reed for the court. So I'm going to ask you please to turn to 58, which is on page 497 of the bundle. my learned friend relied on paragraph 57, which was just before it, for her point that the question of weight is not for the appellate court unless rationally insupportable. However, it's important to note that those observations are made in the context of Lord Reed saying, if you look at the first sentence of 57, that the validity of the findings of fact made by a trial judge is not aptly tested by considering whether the judgment presents a balanced account of the evidence. That's not helpful to look at whether the judgment is a balanced account. But the next sentence is important. The trial judge must, of course...
So sorry, Mr. Legg, I'm behind you. Which paragraph?
57, my lord.
All right.
I would... yes, sorry. Please carry on.
The next sentence, the trial judge must, of course, consider all the material evidence. And that's important. My learned friend would rely on the brackets that you don't necessarily need to discuss all of the evidence in your judgment. That's right if there's a plethora of material and you don't identify every item of evidence in your reasoning. That's not per se a ground of appeal. It could be that there's something de minimis or not significant.
And these judgments are prepared in advance. I don't know whether it's handed down or spoken, but it would have been prepared in advance. And at earlier stages of the judgment, the judge refers to the certificate. So it's fanciful to think that she didn't have it in her contemplation.
She wasn't aware of it. Of
Yeah,
course she was
yeah.
aware of it. But the issue is, was it considered?
Did she consider it relevant? And if so, what weight did she give it? Answer, we don't know.
Well, I think we know a bit, and I'll make some submissions
Right,
about
okay.
that in due course. My Lord the President asked my learned friend if the Employment Tribunal had ignored the evidence when evaluating it and considering it, would that have been sufficient? Would that be sufficient for us to get home? And the answer again is a clear yes.
Yes. Yes.
Now, paragraph 67. Sorry, my lord. Paragraph 50. I think paragraph 67 is the key one. It's the one that's often cited. You'll probably be familiar with it from other judgments and other decisions. There are 3 points to note about paragraph 67. The first is it's not intended to be an exhaustive account of all cases in which there can be an identifiable error with a fact-finding process, of course. But there are some listed, and two of the ones that are listed are a demonstrable misunderstanding of relevant evidence, and secondly, a demonstrable failure to consider relevant evidence. So clearly, where there is such an identifiable error, the appellate court will correct it. I want to take you to one other case, please, if I may. It's the case of Hovis Limited and Mr. Luton in the EAT. It's in the third volume of your authorities. And it's interesting. The reason I go to it, it's interesting for two reasons. First of all, the category of information in that case found not to have been considered by the EAT. And secondly, some of the language used to describe that. Tab 35.
Thank you.
On page 801, there's a helpful summary of the decision. I could ask you just to glance your eyes across that. One can see the relevant facts from that summary. It's fairly straightforward. A delivery lorry driver was dismissed following an internal disciplinary investigation for smoking while driving. A manager and his wife reported seeing him smoking at the wheel. They did not give evidence to the Employment Tribunal, which found wrongful dismissal. The Employment Appeal Tribunal found that the Employment Tribunal was in error by concluding, in the absence of the manager and his wife giving evidence in person, that the Employment Tribunal, was precluded from accepting their hearsay evidence. They had produced, there was a record of their testimony given during the investigation, the internal investigation. Now, paragraph 21 of the decision is the start of the relevant discussion of the principles. And paragraph 22, and you can see a citation of paragraph 67 from Henderson that I just showed your lordships. Paragraph 22 is a reference to Farrer and Rylett. This is a decision of this court that is in the bundle, but I don't propose to take you to it. It's in volume 2 at tab 32. I don't think we need to go there. Just a judgment of Lord Justice Coulson.
Another masterpiece.
And then paragraph 24, the EAT notes that hearsay is not inadmissible, but importantly, if I could draw your attention to the final sentence of paragraph 24, the assessment of the evidence and what weight to attach to it is, of course, a matter for the tribunal. And that's not controversial. That's straightforward, basic principles of fact-finding. But paragraph 25, the very next sentence, there's no rule that hearsay evidence cannot be considered or given weight by a tribunal. Here the language of failure to weigh evidence at all is the same as not considering it. And then at paragraph 26, the Employment Tribunal should consider the particular circumstances in which the statement was made, the nature of the record of that statement, and so forth. That's the final sentence of paragraph 26. That's important, I say. Now, in the case, the ground on hearsay was considered at paragraphs 43 to 53. I don't propose to go through all of them. I just want to make a couple of points. At paragraph 50, if you could please turn to that at page 814. There's a finding that the judge failed to consider and weigh the statements, and as a result of that, fell into error. Now, this is not a finding that the Employment Tribunal had inadequately assessed the evidence or had somehow considered it but not given sufficient weight. The point being made here is that in not looking at the hearsay evidence, there was no weight at all, no exercise of weighing was conducted by the Employment Tribunal. Both of these authorities, Henderson and Hovis, were before Mr. Justice Bourne, and that's at paragraph 43 of the skeleton before him, which is in for your notes, is in supplemental bundle paragraph, tab 9, page 80 of paragraph 43, as were some other authorities of similar ilk, which I don't think I need to trouble you with. And these principles are mentioned in his judgment, which I would like to take you to, please, at core bundle, tab 9, page 157. Paragraphs 65 to 66. At paragraph 65, recording the submission of my learned leader that the certificate was an important document which deserved weight, and that the employment judge failed to accord any weight to it. So she then goes on to say, it's noted, she further submits that while wholly disregarding a material piece of evidence would be an error in any event, the error was heightened in this case because of section 1.2. And it goes on in the next sentence to say, Miss Darwin submits that by rejecting or disregarding the certificate, the employment judge was in effect finding that the certificate was prepared without the input of the ambassador, and or that its contents were untrue. And she submits there was no proper basis for the employment judge to make those very serious findings. Paragraph 66, the Employment Appeal Tribunal, Mr. Justice Bourne notes the submission made by my learned friend.
Well, he's setting out the submissions here.
Correct, my lord, yes, he's setting out the submissions. And he say, and what my learned friend said to Mr. Justice Bourne was that, in the same way that she said to you earlier, the question of weight is a matter for the fact-finding tribunal. And then at paragraph 69, Mr. Justice Bourne responds to that and says the difficulty is that the employment judge did not appear to give the certificate or unsigned statement any weight at all, by which he's referring back to the submissions made at paragraph 65 that the document was disregarded. Now, if he's right about that, then there's no basis for an appeal,
And if he's wrong?
And if he's wrong, if it was disregarded.
No. If he's wrong.
If he's wrong, then
and we conclude that the Employment Tribunal did give weight to the certificate, but came to its conclusion. What's the result?
If the Employment Tribunal considered it and misunderstood it.
No, they considered it and gave it weight, and Mr. Justice Bourne was wrong.
If Mr. Justice Bourne was wrong, then I accept that this ground of review.
Fine. So it all turns on the conclusion that he gave it no weight at all.
Yes, my lord.
Yeah.
Looking, could we, at the Employment Tribunal decision on this point, it's paragraph 101.
Yes, my lord.
Page 197 of the core bundle.
I'm coming on to address your lordship on this point shortly.
Okay, well, I think it's relevant to the observation my lord's just made. Paragraph 101.
Yeah.
I concluded that the evidence about the respondent's instructions to Howard Kennedy in this case was both partial and unsatisfactory. That's a finding about the evidence. And then 102, the judge lists the evidence. I didn't have the Howard Kennedy file. No one from Howard Kennedy gave evidence. Neither the ambassador nor the deputy gave evidence. I had an unsigned statement from the embassy saying now the ambassador had given authority. So that's the decision about weight. She lists it, the various elements there, and she says, previous paragraph, it was both partial and unsatisfactory.
Yes, my lord.
It's hard to say she didn't bring it into the balancing.
I don't submit to your lordships that this judgment doesn't refer to the document.
No, but it refers to it
Yes.
in illustrating her conclusion that all the things in paragraph 102, and maybe others, supported her conclusion that the embassy's evidence, or the Howard Kennedy evidence, was both partial and unsatisfactory.
Yes, my lord. What I say about this section of the Employment Tribunal's decision is as follows, and it starts at 99, because my Lord Justice Coulson referred to paragraph 99 in discussion with my learned friend earlier. And in my submission, what paragraph 99 does here is summarise the embassy's case on immunity. What it's not doing is discussing all of the evidence. Part of the case refers to the role of the witness, Miss Amel Trevelsey, and the conclusion of the summary submission made on behalf of the embassy is that the respondent contends that the former solicitors cannot have been authorised by the respondent to submit to the jurisdiction of the tribunal. What it's not doing...
But that's all based on the middle bit, for which the only source was the unsigned certificate.
No, my lord, that's not the only source of that information. There was witness evidence on behalf of the embassy by Miss Trevelsey, in which she stated that she had not had authority from the ambassador. So this is a record of her evidence.
Not, I think, by name, and not, I think, both of the ambassadors referred to. Anyway, that we can check that.
My lord,
that's a detail.
I can check that overnight, because
Okay.
it may be an important point. It's troubling your lordship, but my understanding is that is evidence based on what the evidence of Mr.
Anyway, that is also what the unsigned certificate says, so that we may be in danger of going down a rabbit hole.
Yes, my lord.
That is what the certificate
I certainly
says.
accept that the certificate does cover some similar ground, but what it doesn't do in that paragraph is refer to the existence of an official stamped document produced by the embassy, or discuss the implications of how that document would have been produced and the significance of it.
No, that comes at 102.
Well, I'll come on to 102 in just a moment, my lord. At paragraph 101, it's quite important to note that the judge says that the evidence was partial, i.e. incomplete, and unsatisfactory. And at paragraph 102, what the employment judge does is provide a list of how the evidence was partial and incomplete. So she starts off by saying, I did not have the Howard Kennedy file, didn't have a note of the meeting, no one from Howard Kennedy gave evidence, the ambassador nor the deputy gave evidence. I had an unsigned statement from the embassy saying the authority had not been given to waive immunity. That document is identified in a list of evidence that is said to be missing and not available to the Employment Tribunal. She's referring to its existence, but notes that it's unsigned and said, I had an unsigned statement, but this is not complete.
It doesn't say it's missing. I think you misquoted. You said paragraph 101 says both partial and incomplete. It just is partial and unsatisfactory.
Sorry, I said partial, and I said by which she means complete. I don't think there's any suggestion that it means partial in the sense of biased.
No. But
then unsatisfactory.
The word is unsatisfactory.
Correct, my lord. So what happens is 102 in my submission is listing the sense in which the evidence is incomplete. It's an unsigned statement. It's often the case in litigation that if somebody is produced with an unsigned statement, it's said to say, well, I can't really do a lot with an unsigned statement. I can't really give it much weight because I haven't been able to hear the witness. And so I'm frankly in a position that I can't really put much weight on that. I'll have to disregard it. If there's no one going to turn up and give evidence that can be tested by cross-examination, then I'll put it to one side. And in my submission, that's what she's doing here. She's describing this document as an unsigned statement to be put to one side. And then she goes on, my lord, to address your point about the question. She notes that it's unsatisfactory. That analysis, in my submission, is conducted from paragraphs 103 to 108 by reference to the evidence that was before her, namely the witness, Miss Trabelsi, whose evidence she discusses. So at 102, she says it's partial. And then 103 to 8, she says it's unsatisfactory, what I did have before me. She doesn't say...
Well, that's a very chancery lawyer reading of those paragraphs. She says it's partial and unsatisfactory, and then she goes through from 102 onwards.
But she doesn't say anything about the document other than to note...
She explains why it was unsatisfactory, because it wasn't from the ambassador or his deputy.
Well, my lord, with respect, in my submission, that would be reading too much into that sentence. She says it's an unsigned statement, but she's very clear about what she finds to be unsatisfactory in the judgment. She says, for example, at 105, that the evidence of Miss Trabelsi was not credible. She considers the evidence, and the evidence that she says to be unsatisfactory is identified. She also says in paragraph 112 to 113 that there was no direct evidence that the embassy, there had been authority given to Howard Kennedy to draw an inference. But in my submission, there was direct evidence going the other direction produced by the embassy, and that's not considered, which is remarkable. Having been through the evidence of Miss Trabelsi in some detail, paragraph 109, I found it difficult to believe. She says, I found it incredible that Miss Trabelsi, who had no legal experience, at paragraph 108, would have been permitted to correspond with Howard Kennedy, etc. There's no holding back by the tribunal judge in identifying that which she found to be unsatisfactory. No discussion whatsoever in this critical part of the judgment about the official document.
Well, suppose that 108 had begun more generally, and despite the unsigned statement to which I referred in paragraph 102, I also found it incredible that. Would this point disappear?
I don't think it would disappear quite that easily. It may be weakened, I accept that. The reason I say it wouldn't totally disappear is because of the implications of rejecting the evidence are significant in my submission.
Yes, of course they are.
Yes. But one has to understand the implications of the significance of rejecting this type of document in my submission. Yes. And what one would expect if those implications were understood, then they would have been noted by the employment judge.
Perhaps she was being polite.
And she, looking at the evidence as a whole, and she clearly was very unimpressed by Mr. Trabelsi's evidence, and she took the view that individual must have been working on authority from further up the chain of authority. That was a positive finding arising from the fact that she thought she was being dishonest.
My lord, I can see that it certainly reads that way, And and in fact, that making that kind of finding without considering the important contrary evidence is an error. It's not a decision that can be upheld, in my submission. Paragraph 114, she concludes and wraps up by saying, on the facts that I've set out, I infer that she was authorised, as my lord has just identified. But what are those facts? It's the discussion of her evidence. It's not a consideration of the official stamped embassy document. There's no consideration at all of it. And the EAT is, in my respectful submission, correct to say at the critical stage of the analysis, there is a logical leap, even if it's the case that Miss Trabelsi would have had some instructions from somebody. You can't go from that to saying that those instructions came from the ambassador. And at that critical, because they could have been given by anybody else within the embassy, somebody else, you'd have to then say that that person would only have made that decision to authorise the submission to jurisdiction if they had gone away and spoken to somebody within the embassy who had the authority of the ambassador and had discussed and authorised submission to the jurisdiction of the United Kingdom in respect of this case. If we could please turn to the official document. It's in the supplementary bundle.
Sorry to interrupt you. Just for my very boring note-taking, which of your 4 points have we got to?
Yeah, now we're in the third, my lord. This is whether the judge was right to find.
Oh, okay. Yeah. Now I've got that. The official document.
I'm afraid I jumped ahead.
No.
I think I dragged you ahead, didn't I?
What I didn't find is where we moved from 1 to 2, but I'm sure I'll find that at leisure.
We moved into 2 by looking at the Henderson case.
Fine. Okay, got that.
Supplementary bundle.
Yes, supplementary bundle, page 3. I'd ask you just again to cast your eyes over that document. It's on formal headed note paper.
Yeah.
The purpose of the document is stated expressly at the top. It's for the sole purpose of asserting state immunity. It provides confirmation that the ambassador and nor anyone on his behalf waived immunity, and on its face purports to have been prepared by or with input from the ambassadors.
Where'd you get that from?
How else could anybody say that the ambassador did not provide authority? Either that.
Well, nobody has said
something. Well, they said.
I mean, it's just the. I mean, that was the question I was going to ask you. I mean, this is the embassy.
Yes, my lord.
Is that the building? I mean,
my lord.
I mean, what I found puzzling reading the papers was why there wasn't a statement either from the ambassador or his deputy simply saying what the position was.
Yes, my lord. I'll explain, provide an answer to that. I can do that right now, or I could just finish making some.
Take your own course. Take your own course.
Very briefly. There's a section in the document that says neither the ambassador nor anyone working on his behalf has waived state immunities. It's a positive statement that whoever drafted this statement must have taken instructions from the ambassador, or there's something nefarious going on. There doesn't appear to be any alternative.
Perhaps there is. I mean, the word purportedly struck me in the main paragraph, line 6. Purportedly sent by Howard Kennedy on behalf of the Royal Embassy, Saudi Arabia. Of course, it was sent by Howard Kennedy.
On behalf of the embassy?
Yes.
That's the critical question. I think the word purportedly is identifying on whose authority.
So if the sentence said the email dated the 9th of April was sent by Howard Kennedy purportedly on behalf of the...
But in fact, nobody knew this, but they had no authority to be acting in the matter at all.
They had no authority.
Clearly acting unprofessionally.
No, my lords. They had no authority to submit to the jurisdiction. That's quite a distinct question. That they then having authority to act generally in the case. It's an important distinction to draw. Waiving state immunity requires the authority of the ambassador, who is authorised to submit to the jurisdiction on behalf of the state. At the end of the
It's a surprising step to take if you are acting for an embassy.
Indeed,
to
my lord. Indeed.
hand in one of your
If
trump
you
cards.
have immunity, why would you waive it?
Yes. So for Howard Kennedy to do that, there's then it's not well,
Yes, my lord.
a significant matter.
At the end, there's a line that Mr. Justice Bourne describes at paragraph 32 of his decision of being in the manner of a signature, the words Royal Embassy of Saudi Arabia, followed by the embassy's stamp. Can I please ask you to turn up volume 4 of the Authorities Bible, which is the Diplomatic Privileges Act, which also contains the extracts of the Vienna Convention on Diplomatic Relations that are...
So this is the very back of this.
Yes, my lord. Yeah. And this addresses my Lord Justice Coulson's point. Why wasn't a witness statement put in? And if I can please ask you to look at Article 31.2 of the Vienna Convention, which is in one of the schedules to the Act.
Article 31,
Subsection 2,
yes.
page 1270.
Yeah.
1270.
1270.
No, I've got it at 1287.
Oh, this is we've got
You can have it
we've got the Vienna Convention.
Yeah.
Pages 1262 following.
Oh yeah, so that page is in the separate.
A diplomatic agent is not obliged
correct.
to give evidence as a witness.
Yes, my lord. That's right. So there's no obligation whatsoever on a diplomat to give evidence.
Not suggesting that there is.
No, but it is
Doesn't meet my question. Why wasn't the one?
because, as a matter of practice, it's often the case that ambassadors will not give evidence in litigation within the jurisdiction that they are representing their government. And on instructions, as was said to Mr. Justice Bourne, it's the embassy's policy that the ambassador does not sign documents that are being or have already been stamped.
But that wasn't before the Employment Tribunal.
No, my lord.
At that point.
No, my
There's a
understanding is
policy
that
not to
particular
sign.
point wasn't, but on instructions it was before the Employment Appeals Tribunal.
The odd thing is that my lords will have greater experience of this than me, but from time to time, depending on the nature of the case, we receive signed statements from our own ministers of state,
Yes.
asking us, for example, to hold part of a trial in private for security reasons. They're not obliged to do that, I'm sure, but it often helps on the particular point in question.
Yes.
So they may not be obliged, and they may have a policy not to. But when you've spent 2.5 years leading somebody on that their case is within the jurisdiction, one might have thought that the very least that one could do is say, I'm terribly sorry, actually there's been a cock-up, and here's the position.
My lord, in paragraph 70 of the Employment Appeal Tribunal's judgment, that point is also addressed. And Mr. Justice Bourne notes that there was a difficulty at the time because there was a dispute between the embassy and its instructing solicitors. So even if the ambassador himself was not in a position to produce a witness statement, and that can be for legitimate reasons.
Again, that's what he was told. There's no evidence about that. Again, that's on instructions. It's fantastically unsatisfactory, Mr. Legg, isn't it?
I think the Employment Tribunal was also noting this. I don't think this is on instruction.
The only evidence we've got, if that's what it is the stamped statement.
Yeah, but what there wasn't before the Employment Tribunal was a witness statement of the instructing solicitors at the time of Howard Kennedy, because there was a replacement of solicitors, and that's an regrettable occurrence. There was. You're right.
But I have a natural aversion to "I am told that."
I'm afraid
I mean,
that's drafting that I'm not.
It's just, it doesn't give a very good impression.
And my inference of Mr. Justice Vaughan's head, that didn't happen. I'm told that is because of a dispute between the respondent and its former solicitors.
Yeah.
That presumably there was a dispute about outstanding fees and the solicitors were hanging on to their papers. That's the only possible reason, because otherwise, if the client calls for the file, the solicitors are bound to hand it over.
Yeah.
So the embassy are saying we're in dispute with our former solicitors about their fees, so you'll just have to take our word for it.
Well, they do slightly more than that. They produce an official statement and setting out the position of the embassy.
Yes.
And in order for that to be rejected, in my submission, that would require consideration. And the implications of rejecting it are significant. And if I can ask you please to turn up the case of J. Singham in the authorities bundle at tab 13. I think that's in volume 1.
Yes, but we've got a technical problem which will take 3 minutes. I'm surprised you probably want to break anyway. So shall we come back at past by that clock?
All right. There was one bit in the you didn't go to, which is in paragraph.
I would like to work out who people are from email signatures. Who?
So this is
Yeah. Brady. Oh, gosh. They're not all like this, I promise.
This is what the ground says. Madam, I assume if the court's happy to do so, you've no objection to going to 4:30.
I don't. Are you suggesting that what will that do about timetabling? Will that mean you finish half an hour early tomorrow?
Well, we'll see. But it just means we've got no risk of running late tomorrow.
Yeah, there's no objection from my end to sitting until 4:30.
Right.
But
Obviously, Andrew's had quite a few questions.
yeah, no objection from my end. But obviously, if we're being, sorry, Claire, if I could just finish. To note that we're being relatively relaxed about timetable. If relaxation needs to happen the other way tomorrow.
Yeah, understood.
But I don't think we should presume that they will, as it were. Happy to be asked, but.
Court rise.
Is everything all right? You all right? Good. Good. Yes, Mr. Legge.
Thank you, my lord. I'd ask you to turn, please, to J. Singham, which is the authorities file, tab 13, I think, volume 1.
Yes.
If I could please ask you to turn, the facts are in the head note, I don't think I need to trouble you with them. Page 191 of the bundle, at the bottom of that, forgive me, I'm just finding it. Yes. If you could have a look at the bottom of page 191, please. There's discussion there about the fact that no evidence was adduced to contradict what was set out in the High Commissioner's draft affidavit. So in that case, the High Commissioner produced a draft affidavit which was annexed to a witness statement of Mr. Locke, the solicitor. And in due course, the Employment Tribunal rejected the evidence, both of Mr. Locke and of the draft statement of the High Commissioner. And that was expressly done by the Employment Tribunal. The evidence was considered and noted. And importantly, the EAT finds at the end of that paragraph over the page at the top of page 192. In his absence, he was then accused, not by the employee's representative, but by the Industrial Tribunal itself, of inventing his evidence, and that appears to us to be intolerable. Now, there was no express consideration of the official document by the Employment Tribunal in this case, but in not considering it or disregarding it, but reaching an inference diametrically opposed to that which was stated in the official document, the result of the inference made by the tribunal has the same intolerable consequences that the evidence of the ambassador that was taken in producing that document, or at least it looks like prima facie it was taken in producing that document, has been rejected. And at the least, it was found not to be correct.
But in this case, there was evidence, in this particular case,
Yes.
there was no evidence other than the solicitor's statement and the draft affidavit attached to it.
And the solicitor gave oral evidence and was cross-examined.
No evidence was adduced to contradict what was set out.
And no evidence was adduced in our case either to contradict
No,
the
that's not what the judge found. The judge found on the basis of Miss whatever her name's it,
Trabelsi.
evidence that effectively there was a conflict.
Well, she rejected the evidence, but she didn't engage in that conflict.
Well, that's a separate point. We have that point about not, but this is a very different case on very different facts. So it seems to me.
My lord, they're both the same in the sense that there was no competing evidence going the other way. in this case. There was evidence that was rejected by the Employment Tribunal. Ms. Trabelsi gave a witness statement consistent with the official statement of document. Her evidence was considered to be not credible by the Employment Tribunal, but it wasn't worlds apart in the sense that in finding that the document itself is wrong by inference without any other supporting evidence.
We have to be careful,
The
as
implications
the
are
judge said here, we have to be careful not to arrive at a conclusion whereby effectively the tribunal is bound to accept the evidence full stop.
My lord, that's right. And all I'm seeking to persuade your lordships of is that this matter is properly to be remitted to the Employment Tribunal.
Well, I follow that. I follow that.
I'm not asking you to make any findings
I follow.
other than that. So, my lord, that brings me to the end of the stage 3 of my analysis,
Yeah.
and on to stage 4. These ones are sort of wrap-up grounds because they're effectively encompassed within the other arguments. Namely that my learned friend says that no error of law to say no weight absent a perversity appeal. And as I've shown your lordships in the Henderson case, that's simply incorrect. If there's an identifiable error of law by disregarding a material piece of evidence or misunderstanding it or failing to consider it, then that is properly an error of the fact-finding process, and the appellate court should intervene to correct the situation, and remitting the matter to the Employment Tribunal is entirely proper in the circumstances. The second point is that my learned friend says that only if there's a rule of evidence would the nature of the document have any relevance. And I'd say that that's wrong. She makes that point starkly at paragraph 44.3 of her skeleton argument. That's in the core bundle, tab 5. You may have it separately, and paragraph 44.3. But if you're looking at it in the bundle, it's at page 116. This is in the context of my learned friend discussing the authorities that we referred Mr. Justice Bourne to that discuss the nature of an official document. And at paragraph 44.3, my learned friend says that the respondent's authorities could only be relevant if these authorities established as a matter of law that documents such as the unsigned statement should be afforded a particular weight, such as to displace the default position that weight is a matter for the first instance tribunal. With respect, that's not correct. If the Employment Tribunal has misunderstood the significance of a piece of document, a piece of evidence, or disregarded it or failed to consider it at all, then that is an identifiable error of law. And if in the course of reaching that conclusion, the Employment Appeal Tribunal, Mr. Justice Bourne, considered the nature of the evidence and the significance of it, then that's entirely appropriate. There doesn't need to be a rule of evidence as to the particular status of the official stamped document in order to find that it is material. And in my submission, that is a bad point. And it's important to bear in mind that the failure to weigh a document at all is an identifiable error that can be corrected. My lords, unless there's anything else you would like me to address you further on, I'm going to give way to my learned leader.
No, Mr. Legg, thank you very much. If you want to move around more fundamentally, then yeah.
If I might, my lord, just move this back.
Yeah, no, we'll general clear out.
Grateful, my lords, while we just play musical chairs here.
Yes.
My lords, looking at the time, I wondered whether you would allow us to continue until at least 4:15 or possibly even 4:30, or whether you wanted me to finish at 4 o'clock on the dot.
No, I don't think we have to be back in the day room before 4:30. So it's
I'm very grateful. So I propose now to address you
that's right.
on 5 matters relevant to the legal
So if
framework.
we 4:25, I think is
4:25.
Thank you, great.
We'll make a note of that. I'm going to address you on 5 matters relevant to the legal framework. They're mainly relevant to grounds 2 and 3, but also touch upon matters relevant to our appeal. And I'm hopeful that I can deal with those 5 matters before 4:25.
25.
Sorry?
4:25.
4:25. Yes.
Sorry,
Don't
I
worry.
thought you said
I have that.
4:35. I thought you were sneaking.
No,
in
I'm not
another 10 minutes.
sneaking an extra 10 minutes.
Said 25. Yes.
I've written that down correctly. Thank you, my lord. So the first matter I want to address you on is one, as I understand it, that this court hasn't had an opportunity to consider in any detail yet, which is who are this middle category of staff in a diplomatic mission? Who are these administrative and technical staff? And what does international law have to say about them? And the reason why this matters is because, and I think Ms. Stanley showed you this earlier on today, is that the definition of a member of a diplomatic mission in the 1978 Act refers you back to the Vienna Convention. So I propose to turn up the Vienna Convention, which is now hopefully at the back of all of your bundle 4 of the authorities bundles, but I don't know if my Lord Justice Coulson now has it.
I have
I'm
them
very-
separate. Yeah.
I'm very glad to hear that. So we've been calling it, although I don't know if you've actually have a tab 51.
But I've got page numbers, so
1262, if you don't have any tabs.
Sure.
So this is
Are you going to tell us what the 5 points are going to be, or are you
Oh,
going to
yes.
take them one by one?
very well. For your note, my lord, so the first point is about administrative and technical staff, and as I'll come on to explain, you might think we're talking about secretarial staff, but in fact, as I'm going to come on to show you, it's just about their function relative to diplomats. So we're talking about doctors, high-level policy officials, and so on and so forth. The second point is the origins and evolution of the restrictive doctrine of state immunity, which of course is what the 1978 Act sought to put into effect. The third point is about how do you identify a sovereign act? So how do you distinguish between a sovereign and a non-sovereign act? The assumptions dividing line that we've been talking about. The fourth point is about state immunity in general, how it operates, where it's derived from. And the fifth point is just to go back to the 1978 Act. I'm not going to duplicate anything that Ms. Stanley's shown you, but there are a few parts of the 1978 Act that you haven't looked at yet, which are relevant to the embassy's appeal, particularly the matters I'm going to address you on tomorrow. So starting then with my first point, which is who these administrative and technical staff are. The Vienna Convention on Diplomatic Relations, 1961, is in the authorities bundle 1262. And as you'll be aware, my lords, diplomacy involves the exchange of permanent diplomatic missions. And we can see from the preamble to the Vienna Convention that the purpose of the privileges and immunities enjoyed by diplomatic staff is not to benefit those individuals, but to ensure the efficient performance of the functions of diplomatic missions as representing states in foreign countries. And we know, because Lord Sumption made this clear in Ben Capuche, but we'll come back to this probably tomorrow, that the exercise of those sovereign functions is essentially sovereign. That the functions of diplomatic missions are essentially sovereign functions. A diplomatic mission isn't just the embassy building; it's the entire notified entity used for the purposes of the diplomatic mission. I say that because, of course, here the part of the embassy concerned was the Cultural Bureau. But that doesn't matter. That comes within the diplomatic mission of the Kingdom of Saudi Arabia in the UK, and therefore it shares the status of the diplomatic mission and it carries out its functions. The functions of a diplomatic mission are described at Article 3 of the Vienna Convention, which is over the page at 1264. And you can see there's a list there. It's a non-exhaustive list of the functions of a diplomatic mission. And you'll see that Mr. Justice Bourne accepted that the functions being exercised by the Cultural Bureau that were of relevance to the claimant's functions were B, so that's protecting in the receiving state, the United Kingdom, the interests of the sending state, Saudi Arabia, and of its nationals within the limits permitted by international law, and also E, promoting friendly relations between the sending state and the receiving state and developing their economic, cultural, and scientific relations. So who are the members of a diplomatic mission? We have a definition at Article 1, which if I could invite you to turn back the page to 1263. So Article 1b says the members of the mission are the head of the mission. So it can only ever be one head of the mission, so that's typically the ambassador, and the members of the staff of the mission. Who are the members of the staff of the mission? Well, C, they are the members of the diplomatic staff, of the administrative and technical staff, and the service staff of the mission. So those are the three categories. And they are then further defined. So you have at F, the members of the administrative and technical staff are the members of staff of the mission employed in the administrative and technical service of the mission. And similarly, over the page, you can see there's a definition of who the service sign are. Important to understand that Article 1 divides the staff of a diplomatic mission by function. It is not a hierarchical divide. And this is particularly relevant to some of my learner friends' submissions on the ground 2, on the correct test, and also whether the test was correctly applied. And the reason why Article 1 focuses on functions is because of the distinctions that I'm about to show you in the Vienna Convention about the legal status, privileges, and immunities enjoyed by these three different categories of staff within a diplomatic mission. And just to give you an example, you could have a junior attaché who performs consular duties, who would be a diplomatic agent, and they may be significantly less senior than a regional security officer or a chief medical officer, but the regional security officer and the chief medical officer, who wouldn't be diplomatic agents, would be administrative and technical staff. So important to understand, this is not about hierarchy, it's not about seniority, it's about functions. And I'll show you what the Vienna Convention says about the legal status of administrative and technical staff. The first point to show you is what is said at Article 19(2) of the Vienna Convention, and that's on page 1268. And that says that in cases where no member of the diplomatic staff of the mission is present in the receiving state, a member of the administrative and technical staff may, with the consent of the receiving state, be designated by the sending state to be in charge of the current administrative affairs of the mission. So it's a sort of deputising for diplomatic staff, although only insofar as they're in charge of the current administrative affairs of the mission. As you will probably be aware, diplomatic agents enjoy significant privileges and immunities, and those are dealt with at Articles 29 through to 35 of the Convention. So to give you some examples, a diplomatic agent can't be arrested or detained. They are immune from the criminal jurisdiction. They're exempt from social security and taxation. But important to understand as well that there is essentially a descending scale of protection whereby administrative and technical staff also enjoy some of those privileges and immunities. And we see that from Article 37.2 of the Vienna Convention, which is at page 1272. And that sets out that members of the administrative and technical staff of the mission, together with members of their families forming part of their respective households, shall, if they're not nationals or permanently resident, enjoy the privileges and immunities specified in Articles 29 to 35, and goes on to detail those.
Subject to exceptions.
Indeed, yes. And it's also right that there's an exception in relation to UK nationals. And important to understand as well that service staff of the mission, like the employees in Ben Carbuche, they also enjoy some immunities and privileges, but less than administrative and technical staff, and of course less than diplomatic agents. So, for example, they don't have the same protection against being arrested or detained.
So it's hierarchical to that extent, in that the privileges dwindle
There's a
on those, depending on which function.
Yes,
Yeah.
indeed. There's a descending scale of protection,
Yeah.
but that's not really about seniority. It's a function.
It's not about seniority of the staff. It's about,
Yes.
as you say, about function.
Yes,
Yeah.
because I wouldn't want this court to think that administrative staff just means secretaries.
No.
It is, in fact, easier to define administrative and technical staff by what they don't do than what they actually do. So we know, for example, they're not diplomats, so they're not the ambassador, they're not the cultural attaché, the financial attaché, and so on and so forth.
Well, you may have to persuade me, certainly, that a cultural attaché is necessarily a diplomat.
My understanding, but this is probably a matter of practice rather than law, is that anyone who was given the role of a cultural attaché would be a diplomatic agent. But perhaps let's stick with ambassadors. But certainly, administrative and technical staff are not diplomats, so they are not diplomatic agents.
Yeah.
But nor are they staff in the domestic service like the cleaners in Ben Carbuche. So they are in this middle category, which, like I said, is defined more by what they're not than what they are. We have some examples given by the International Law Commission in their guidance on state immunity. So they include, the examples they give include interpreters and translators, and other persons entrusted with functions related to state security or the basic interests of the state. But as I'm going to show you, some of the examples in the case law include medics, teachers, and as I said, somebody who was a regional security officer, equally someone who was a public affairs official, or somebody who was a lawyer. They would also all be within the administrative and technical staff. As we know, so that is, by way of brief overview, who the administrative and technical staff of a diplomatic mission are, as defined by the Vienna Convention. The second matter I wanted to address you was the origins and evolution of the restrictive doctrine of state immunity. The reason why I think it's important that the court understands this doctrine is it assists with the definition of what is and is not a sovereign activity, which is essentially the central question for you on grounds 2 and 3.
Well, what do you mean by sovereign activity? I thought in Lord Sumption's judgment in Ben Carbuche, he
Yes.
said in most cases you're looking at the job of the individual. There are some cases where the act complained of, if you like, you have to decide whether the act complained of is a sovereign act. But in most cases, and I thought it was common ground in this one, you're looking at the functions of the individual.
So what he says, and this is, I think you have in mind, my lord, 53, 54 and 55
Yes.
of Ben Carbuche, is he says you have to look, and I'm going to come on to this in a moment, but
Yes.
he says you have to look at the context. So you look at where the employee was working and what everyone around them was doing. Then you look at what they were doing, and then you look at the nexus between the two. That's a sufficiently close test. So it's not sufficient in my submission just to look at what the employee was doing, because that would be to ignore the whole context. And what comes through all of the case law and state immunity, whether it's case law on shipping or case law on employment, is what Lord Wilberforce said in I Congresso, which is the importance of taking a step back and looking at the context. And it's for that reason, and we'll come to this case probably tomorrow now, but when you have teachers working on an armed force base, that they are held to be exercising a sovereign function, because the context is the base. But when you have obviously a teacher in a normal school down the road, that wouldn't be the exercise of a sovereign function. So you can't ignore the context within which any of these individuals are working. But I think the same case says if you were concerned with somebody who's just going out to collect the milk and bring it back to the military base, then there wouldn't be a close nexus there between the exercises of a sovereign function. So I was about to take you to what Lord Sumption said in Ben Carbuche about essentially the history of the restrictive doctrine of state immunity, and Lord Sumption spends, perhaps as of course he would do, a lot of time on the history of the restrictive doctrine, which I do say is helpful in terms of understanding the concept of sovereign activity. So if I could start by taking you to paragraph 40.
Tab 27.
Forgive me, it's tab 27 of Authority Bundle 2. And as you can see from paragraph 40, and I'm not going to read out these paragraphs, but I'll just highlight what he says, and then you may want to come back to them later on, is he explains how state immunity was developed during the 19th and 20th centuries, primarily by municipal courts. And essentially, the occasion on which state immunity came to be tested related to ships owned by foreign states. And we can see at paragraphs 41 and through to 51, he recites a number of these key cases. And then at paragraph 51, he says that the main impetus for the adoption of the restrictive doctrine of state immunity was the growing significance of state trading organisations in international trade. And then he goes on to explain why the Tate letter was a critical moment in the evolution of the restrictive doctrine. And he sets out stated intention of the set out in the Tate letter, and then he says following the Tate letter, the restrictive doctrine was generally adopted by various other courts, and he goes on to explain that. And then at paragraph 52, he says 3 points can be derived from this history. And I particularly wanted to draw your attention to the third point. And he says, thirdly, the adoption of the restrictive doctrine has not proceeded by accumulating exceptions to the absolute doctrine. What has happened is that government, courts, and writers of authority have been prompted by the widening scope of state operations and their extension into commerce and industry to re-examine the true basis of a doctrine originally formulated at a time when states, by and large, confined their operations in other countries to the classic exercises of sovereign authority. And so, essentially, the restrictive doctrine developed out of foreign states engaging in trade and commercial activities. So, and we'll come on to this in a lot more detail tomorrow, but what is a sovereign activity? Well, we know what it's not. What it's not is a commercial activity by a foreign state, trading, borrowing, commercial dealings, and so on and so forth. So that is the antithesis of a sovereign activity. And that is, of course, we say, worlds away from what you're concerned with today, because we say what you're concerned with today is what Lord Sumption refers to as a classic exercise of sovereign authority, namely having a permanent diplomatic mission in the UK in which administrative and technical staff are employed to carry out diplomatic missions.
But that's circular. If you phrase it like that, then everybody's immune.
I'm obviously not saying that. I'm saying only the staff whose employment is an exercise of sovereign authority are immune. So I'm not suggesting that domestic staff, service staff are immune.
No.
That's obviously changed in the order. But as Mr. Justice Bourne held, the claimant's employment was the exercise of sovereign authority. And so we do say that this court should uphold the position of the Employment Appeal Tribunal that the respondent is immune, obviously subject to the waiver issue, is immune in relation to the proceedings in relation to her employment. The third matter on the legal framework is on this distinction between sovereign and non-sovereign activities. The courts in the United Kingdom have developed a functional test to distinguish between commercial or private law acts and sovereign acts. And as I said, that functional test applies across the board. So it doesn't just apply to employment cases, it also applies to some of these shipping cases that you have in the bundle. And that test is in fact a common law test identified by Lord Wilberforce in the I Congresse case. And although that judgment was handed down after the 1978 Act had been made, it was actually considering the common law position. And when I take you to Ben-Carbuche, what is striking about Ben-Carbuche is Lord Sumption's judgment, paragraph 53, cites Lord Wilberforce, the I Congresse, and that is that the court must consider the whole context in which the claim against the state is made, with a view to deciding whether the relevant acts upon which the claim is based should, in that context, be considered as fairly within an area of activity, trading or commercial or otherwise of a private law nature in which the state has chosen to engage, or whether the relevant act should be considered as having been done outside those areas and within the sphere of governmental or sovereign activity. And as I mentioned earlier, that's sometimes referred to as the whole context test. So it's about spheres of activity or context. And when we look at Ben-Carbuche, I'll show you at paragraph 53, that remains an important part of the test that this Employment Judge Brown was supposed to apply but didn't apply. The fourth background matter is about state immunity in general, so not only as a matter of domestic law, but as a matter of international law. As you'll be aware, state immunity derives from the principle of sovereign equality of states, so all states are equal. It is one of the fundamental principles of the international legal order. And it is not, as I alluded to earlier on this afternoon, a mere matter of comity. It's a matter of international law. There are essentially two parts to the obligation. Firstly, a foreign state has a right to immunity under international law, but there's a corresponding obligation on the part of the other states, so including the United Kingdom, to respect and give effect to that immunity. And Mr. Legg took you to section 1.2 and the duty of inquiry. That's all part of the duty on the United Kingdom to give effect to that immunity, save in cases recognised by international law. The United Kingdom has no jurisdiction over another state. And that, of course, is particularly relevant when we come on to the right-wrong question. Because if you have no jurisdiction over another state, that has to be a question that there's only one right answer to, and therefore why we say Mr. Justice Bourne was right to think there could only be one right answer as to whether the United Kingdom has jurisdiction over my client or not. A failure to give effect to that immunity and the exercise of jurisdiction by the courts of England and Wales over my client, a sovereign state, it is a breach of the United Kingdom's legal obligations under international law. And this is particularly relevant to the embassy's appeal, because we do say that the interpretation of the personal injury exception would lead to a unilateral assumption of jurisdiction by the United Kingdom over the sovereign functions and activities within every diplomatic mission in the UK potentially, and that would be a clear violation of the sovereignty of foreign states who've established diplomatic missions in the UK, which is of course something that's done by mutual consent. So the UK consents to those diplomatic missions being established here.
But of course, if it was a violation, it's been a violation for years.
The interpretation of Section 5?
Yes, because, I mean, part of your argument is that Ogbonna's wrong.
Indeed. Although in practice, as I understand it, there have only been a handful of cases. So I suppose it's been a violation on a handful of occasions. But yes,
it goes both ways, doesn't it?
Yes. But we do say to send the case to a full trial, which would involve a British employment tribunal investigating the internal workings of the Saudi diplomatic mission in the UK, which is what would happen if the case was allowed to proceed on the basis of the personal injury exception. We do say that that would be an unlawful interference with the sovereign activities of the diplomatic mission. My fifth and final point is just to take you to those parts of the 1978 Act that the embassy particularly relies on that I think you haven't been shown as yet. Like Mr. Legg, I'm going to take you to the 1978 Act in its current form, which you have at tab 1 of Authorities under 1. The reason being that although it's right that the remedial order wasn't in effect at the time of the Employment Tribunal's judgment, the judgment in Ben-Kabouche had been handed down, and it's common ground that the remedial order simply puts into effect the judgment of Ben-Kabouche. So we say essentially there's no real difference. You either look at the 1978 Act as amended by the remedial order, or you look at the old legislation in conjunction with Ben-Kabouche. So we say it's just easier to look at the updated 1978 Act. So the first point I want to take you to is the general immunity from jurisdiction, which is at section 1.1. And I just want to draw your attention to the wording of, so a state is immune from the jurisdiction of the courts of the United Kingdom except as provided in the following provisions of this part of this Act. And I'll come back to this in more detail tomorrow. But we say essentially that they are not freestanding exceptions, but should be read together as cumulatively describing the circumstances in which the general immunity does not apply. And also important to understand that whilst this Act does lay down a number of exceptions to the general immunity, it can't confer jurisdiction on the English courts, which you would otherwise not have. So there's general immunity, and then there are the exceptions. A point that Mr. Legg was asked about, which was about the burden of proof. He was asked about that in the context of waiver, but in relation to both the employment exception and also the personal injury exception, and indeed any of the other exceptions, the burden on proof is on Dr. Alhayali to prove that she comes within that exception. You've seen section 4, which is the contracts of employment exception, but I just wanted to take you to section 16, which is the exception to the exception, which is at page 11 of the authorities bundle, because I think Ms. Stanley took you to the unamended version. What I wanted to particularly draw your attention to is the fact that under the heading excluded matters, section 16.1 provides that this part of this act, so that's a reference back to the whole of part 1, does not affect any immunity or privilege conferred by the Diplomatic Privileges Act 1964. That's the legislation which essentially has the Vienna Convention as a schedule to it, or various parts of the Vienna Convention as a schedule to it, or the Consular Relations Act 1968.
That's not relevant to this case.
It is, in fact, relevant to this case, my lord, because it's part of our argument in relation to the personal injury exception. So, as I'm going to show you tomorrow, section 16.1 is derived from Article 32 of the European Convention on State Immunity. And essentially we say, and this is also clear from the explanatory notes to that convention, that it's intended to be a saving in relation to employment in a diplomatic mission when you are exercising sovereign functions. So I'm going to make those points tomorrow, but I just wanted to draw your attention to section 16.1. Section 16.1a is the exception in relation to diplomatic agents or consular officers. My Lord, Lord Justice McFarlane made an observation earlier on about the differing treatment of the three categories. And the way that works, my Lord, just to reiterate that, is diplomatic agents have absolute immunity under A. Mm-hmm. Under AA, all of the other staff, so whether they are administrative and technical staff, or they fall into AA. So the question then is, and either 1, the state entered into the contract in the exercise of sovereign authority, or 2, the state engaged in the conduct complained of in the exercise of sovereign authority. So whilst AA applies to both administrative and technical staff and service staff, for the reasons explained in Ben Carbuche, it is unlikely that any member of the service staff would ever come within Roman 1, because the state didn't enter into the contract in the exercise of sovereign authority. But it may be the case that you may have some service staff that fall within Roman 2. So, for example, someone who was dismissed for selling state secrets or something along those lines. That's an example given by Lord Sumption of someone who could fall within Roman 2, even if their employment, so their functions, aren't themselves exercise of sovereign.
But that's not this case.
No, it's just to understand how the Act works,
yes.
And in relation to the question that the President asked earlier on this morning. So yes, the only exception that you're concerned with is AA, small Roman 1. So the question is, the state entered into the contract in the exercise of sovereign authority. And at 16.1a, you can see definitions of consular officer, diplomatic agent, and member of the diplomatic mission. And as I alluded to earlier, they're all defined by reference to the Vienna Convention. And my first point on my feet was to take you to those definitions of the Vienna Convention. So these exceptions are very much grounded in the Vienna Convention and how the Vienna Convention analyses the members of a diplomatic mission. And then the last point, with I think still 12 minutes to go, is to take you to section 16.2. And you can see there that there's now an exception in relation to the armed forces. And the reason why I mention that now is because it's relevant to a case that we're going to look at tomorrow about how as a matter of customary international law, sovereign activities has been interpreted. So, my lords, those are
Holland and Lamp and Wolf.
it is, my lord, but there's also a case about the activities of the Wehrmacht during World War II, which is an ICJ case when essentially Italy was allowing lots of Italians to bring cases in Italian courts in which they were seeking damages for the conduct of the armed forces of Germany during World War II. And eventually the matter went to the ICJ, and I'm going to take you to that tomorrow in the context of the personal injury exception.
Right.
But I just wanted to show you that because it's relevant to the submissions that I'm going to be making tomorrow. So, my lords, unless you had any questions for me, those are my five introductory points. Yes.
That's very efficiently done, thank you. I'm just looking at, we've got section 16 open as amended. And section 1AA,
yes.
1, you say, applies. So 1AA applies if an individual was employed under a contract as a member of a diplomatic mission, other than diplomatic agent, was a member of the consular post, other than consular officer. Then those are defined by reference to the categories in the Vienna Convention.
Yes.
I think we got to in the Vienna Convention that there was a category members of administrative and technical staff, which I think we were saying was category 2. So does a category 2 person fall within 1AA?
Yes. So, my lord,
If so,
it might help if I just take you back there, since we do have 12 minutes to spare.
Well, we don't have to use it, but...
So, my lord, it's a little bit complicated, but the answer to your question is Article 1C of the Vienna Convention on page 1263.
It's service staff.
There are 3 categories.
Yeah.
Members of the diplomatic staff, the administrative and technical staff, and the service staff of the mission.
Yeah.
And then if you look then at AA, so what they're saying is that applies to anyone other than the first category. So it doesn't apply to diplomatic agents, but it could potentially apply to the other 2 categories. But then obviously we have what Lord Sumption said in Benkabuj, which is that the employment of somebody in the service staff can never be the exercise of a sovereign function.
The bit I missed was that in AA, member of a diplomatic mission, then at A capital, 1 capital A, 4th definition, member of diplomatic mission is to be construed in accordance with Article 1B of the Vienna Convention, and 1B is members of the mission, the head of the mission and the members of staff.
Yes.
And the members of staff is everybody. Yeah.
Well, yes, and then the members of the staff is C, the 3 groups.
Yeah. So
and then we discount the diplomats, then we're left with the 2
This was the
groups.
concertina you opened up, so everybody's in there. Yeah.
Yes, yes.
Good.
Thank you very much.
Anything? No? Good. Right, well, we were optimistic in our reduced time expectation, but
we are on schedule, my lord.
we're on schedule. Good. So we'll sit again at 10:15.